My name is Kylie Walker. I'm the communications manager with the Beacon Center of Tennessee here at our office downtown. We are a public policy think tank, and we are the ones hosting this webinar today. We have a great line of panelists. We're excited to walk through, obviously, a very big topic that most people kind of think about in their everyday life is just housing. And we all know it's getting harder and harder to find affordable homes, whether you're renting or a buyer or builder. You're really feeling it. So we want to touch on some of the aspects today in this webinar, behind the costs, regulations, red tape, rising fees, all of those things that will really impact property rights. And that's why we're hosting this today, kind of dig in, share solutions, hear from our panelists. So we do have Ben here. He is our Beacon attorney. If you wanted to waive Ben, he handles all the lawsuits. That includes property rights cases too. We have Jason, our Deputy Director of Policy at Beacon. He conducts a lot of our research. Jim with the Pacific Legal Foundation, also the author of a book called Nowhere to Live, The Hidden Story of America's Housing Crisis. You could see that right behind him. And then we have John with the Home Builders Association of Middle Tennessee. So we want to get started because we have a lot to talk about, a lot of important issues. Again, we want to talk about housing affordability, if that really is a problem. We hear about affordability all the time. So I will starting with you, Jim, since I see you on the screen already. You've been in this space for a while. What have you seen in terms of housing affordability? Is that really a problem? I think you're muted, Jim.
Someday I'm going to learn how to put the mute button off. I've been litigating property right issues for 42 years. And in my experience, the common theme of so many of my cases is somebody wants to do something with their land. They want to farm it, they want to cut trees, or they want to build homes. And people come in to sue to stop on a whole variety of reasons. It doesn't conform with zoning, planning, environmental restrictions, an endangered species here, a wetland there. But the bottom line is that it has become more and more difficult to build homes in America. It used to be that in the 1960s, if you had an average income, you could buy a house that was twice your annual income. And that was a good ratio to have. Realtors think 2.6 is the ideal line for that. So if you're earning $100,000 today, you should be able to find a house to meet your standards of living at $260,000. But in fact, Eastern cities, the amount of a house costs 5 times your annual income. In some Western cities, averaging 8 times, and there are even cities in California where 12 times your annual income. So if you earn $100,000, the typical house that would be available to you is $1.2 million. That is unaffordable. So yeah, we have a problem. And the common theme of the litigation that has led us there is that courts give less and less respect to property rights. They do not respect the ability of landowners and property owners to build and improve on their land. We are subject to all kinds of restrictions. Now, I'm not going to get into a long legal lecture, but a lot of it began in the 1920s, especially in a case in 1926 called Euclid versus Ambler, which basically the Supreme Court said zoning was okay. Zoning had at that time a racial component to it. It was to keep minorities and poorer people out of multifamily or apartment buildings. Apartments were considered by the Supreme Court, and I quote, a parasite on the community because you didn't like the sort of people moving into the multifamily housing, immigrants and minority populations, people of that nature. Now, today, we need to build roughly 2 million homes per year just to keep up with population growth and obsolescence of existing homes. Now, if I could show you out my window right now to give you an idea, you can see haze and smoke. This haze and smoke obscures what I saw several days ago, which was billowing smoke from a large forest fire of 122,000 acres, roughly 30 miles to my southeast. That fire is in a rural area, not destroying too many homes. But where we have examples of fires destroying homes, such as Santa Cruz, California, 700 homes are destroyed, and we've had only about 100 or 200 rebuilt since 2020. Malibu, We lost roughly 2,200 homes, and it's going to be decades before that's built. So what have we done? We've made it more difficult. We had a new law in California saying you could build duplexes on single family homes. But the mayor and the governor immediately moved in under NIMBY pressure saying we're not going to allow duplexes on single family lots. 95% of the homes destroyed were single family homes. I could look at Maui, where you had 1,200 homes destroyed. And so far, they built 43 homes in the last 2 years. So we have increasingly difficulties of exercising the right to use one's property to build more. In the 1970s, we built 1.4 to 2 million homes a year. We had a population of 205 million. 2015, we built fewer than 500,000 homes, population 331 million. 2024, we built 1.6 million, which was a big increase over the prior year. It's not going to last. Population 340 million. The key reasons is litigation and government regulation preventing new homes. So that's what I've seen in the last 42 years. I thought I could join a public interest law firm and make it easier for people to use their property. And it's turned out every year things seem to be getting worse.
Well, thank you for that insight. Jason, what does the data tell us here in Tennessee, at least?
Well, as Jim said, the population growth, we're just not building enough houses. So Tennessee, 90 of our 95 counties have recently experienced growth. And while census data is fun, another data point that I like to bring up is the U-Haul's growth index, which shows the number of one-way rentals going in and out of states. And Tennessee is near the top or at the top of that list for the last few years now. So Tennessee is such a growing state, and why not? It really is a great state to have. So research has suggested that we just are not building enough homes here in Tennessee. There's tens of thousands of housing units that need to be built just for the current demand. And then with the upcoming demand, we just need to really increase the housing supply here in the state. And just from 2020 to 2024, there was a nearly 50% increase in the average housing costs here in Tennessee. So Tennesseans are really feeling the pinch of these rising housing costs.
And Ben, kind of shifting gears here a little bit from a legal standpoint, how do affordability and property rights connect?
Yeah, so I think they're a huge connection. I kind of want to start a little bit maybe philosophically, and I think as Jim mentioned, that courts don't respect property rights much as other rights, and I think that's also I think with people, right? Is I think property rights kind of get treated as a second class right in society. Yet I think that in many ways they are the most important, or at least one of the most important rights, and that property rights shape a lot of things we do, right? And so, free speech is really popular, but if the government owned the printing press, it's kind of hard to imagine that you actually would have freedom of speech without private property owners owning communication and books and publishing houses. And so I think in the economic sphere too, private property is how free market capitalism works. And in the housing industry, we actually don't really have a very free market because the government controls the way you use your land. It's very centrally planned, it's heavily regulated. And so I think part of the reason why we have this problem is that property rights are not respected. And so property rights are not just abstract concepts, right? They're things that we use and do. Everyone's house is their little castle. People love their homes where they make memories. And so I think as a society, if we respect property rights more, we'll also help fix the housing crisis. In that if people are allowed to use their property and are allowed to do what they see fit, and the government respects our uses, that we will see, as Jim said, more use. People can do different things. The market can determine which kind of home makes the most sense for an area rather than a government bureaucrat. And so I think the legal protections of property rights and kind of the moral foundation of property rights are linked to the practical problem of actually having a housing shortage.
And John, I do want to turn it to you. In home building, what are you seeing on the ground? I know that we also want to share a presentation here that you have for us. So I'm going to share my screen. And then this is the slide that you would like it on, right? You just muted, John. John, I think you're still muted. Good.
There we go. I said such great things under mute. I can't imagine it's gone. But this is what I think sort of dovetails the other side of the coin for what Jim was talking about, and it's sort of the net effect, particularly from the Euclid case. It's almost like that began this slow increasing arch over a period of time where this is where we are now. And I put up here, this is a house. This was actually my house, my first house that I bought back in 1996. It was on an eighth of an acre. It was a little over 1,900 square feet. The siding is 80% vinyl. It's obviously got a front entry garage. There are no sidewalks, above ground utilities. And back in 1996, median income in Tennessee was $40,000 a year. And this house, and it was not the least expensive house in this neighborhood, but this house cost $119,000. So any family that made median income and they had their the credit scores were good and all, they could buy a newly built home. There were actually some homes that were cheaper in there, but there were, if you look down that red circle, that's the whole neighborhood. There's about 200 homes in there. And like I said, the density is about an eighth of an acre, maybe a little bit bigger. And that same builder, those three dots on the side indicate neighborhoods where they were building basically this exact same product. So the home building industry back in the 90s and the 80s and 70s was allowed to build median income housing affordable to median incomes. And that has changed drastically because I guess where the rubber meets the road is it's one thing to have a piece of property, but you have a base zoning. And normally that base zoning isn't dense enough. It could be in some areas, it's 1 unit per 2 acres. And so they'll buy this and they'll say, hey, our developer put an option on it, go to the planning commission and say, hey, I'd like to do eighth of an acre. And they say, well, if you're going to do an eighth of an acre, if you want us to approve that, you need to show us what exactly you're building in there. And that's the rub. That's where all of a sudden, they would not approve this. And part of that is just simply the homeowner class is making rules for the non-homeowner class. Another part of that is, there are communities out there who only want wealthy families moving in, and you can't pass a law that says that. But if you control your housing stock or you're just artificially making it more expensive, that's exactly what's going to happen. So I'm going to stop there, but that really is the root of it, is the for-profit building industry is not allowed to build the neighborhoods we could build 30 years ago.
Well, thank you for that. I'm not sharing anymore. Now kind of keeping to this topic, but shifting gears just a little bit, I want to talk about the biggest drivers of the housing shortage today and what's causing that housing shortage. So kind of why aren't we building more homes? Jim, could you kind of talk on that? And, is government created scarcity a thing?
Yeah, absolutely. The government rules and regulations are creating a lot of our problem today. I mean, in my book, Nowhere to Live, I talk about the rise of zoning in America. And the first zoning ordinance in Baltimore was designed expressly to keep African Americans out of white neighborhoods. Now, the Supreme Court struck that down. And as I mentioned in the Euclid versus Ambler case, other ways were found to do that by making large lot, single family homes that are not affordable to working class people. And more communities across the country have adopted that kind of zoning where it's become very exclusionary, very draconian, and very upscale. You go to neighborhoods of affluent people, whether they're conservative or liberal affluent people, they like their neighborhoods the way they are, large lot zoning, where you can't build the starter homes. I mean, my first home that I bought in 1995, around the time that John started building, was a 900 square foot, 2-bedroom, 1-bath home. And for a young couple starting out, it was perfect. You can't build homes like that anymore in most of America. That was a post-World War II home. So even if you want to build that kind of home and you say, I found a place for it, and I actually found zoning where it's allowed, try going through the permitting red tape. It's not unusual in some states like California for people to call me up and said, look, I've been trying to get this permit for 5 years, 10 years. And every time they want to do another plan check, they ask me for more information. And I finally get to a certain point, and then NIMBYs come in and sue me saying that I should stop. And so litigation is the other part that stops a lot of building, and judges basically sanction this delay after delay from litigation, not understanding that for a builder like John, time is money. And if you have to have a project sitting on the sidelines for 5 or 10 years while you're going through a permitting and litigation process, you can't build a starter home and make up your attorney fees, no less the cost of the labor and materials and land. You have to build an expensive home in order to make up for that. So a builder would be committing economic suicide in large parts of a state like California if you wanted to build starter homes with your own money. Would be ridiculous. I can go through environmental laws and regulations of wetlands and endangered species at length, which I do in the book. But if you have land that is a so-called greenfield that hasn't been developed yet, good luck getting permission to, tear down some trees or some grass or grazing land, because somebody's going to sue you with guaranteed. And they have a good chance of stopping the project and getting paid attorney fees if they win or lose, but not the other way around. They don't pay attorney fees to the developers. I also talk about other constraints. Rent control is a big one. In St. Paul, Minnesota, just a few years ago, rent control was passed with a 3% annual increase, regardless of inflation. There were building projects in the ground, sticks and bricks going up, that were stopped, halted, bulldozers called off, workers called off, because it made no sense to build multifamily housing in a community with rent control. How about Montgomery County? It just passed rent control a little while ago. And in 2022, they had 821 building permits, the first quarter of the year. 2025, first quarter, 7, because rent control was adopted about a year and a half ago. And developers are saying, we're not building where there's rent control or even the threat of that. We have an inexorable failure to meet supply, the demand. We do not build the supply to meet the demand, so prices go up and up. And all these disincentives or impossibilities to new building is causing the housing shortage we're in today. The law of supply and demand is inexorable. You can't overturn it. Soviet Union was not able to overturn it. North Korea was not able to overturn the law of supply and demand. Not even the legislature in California has figured out how to overturn the law of supply and demand, except through exporting our problem, because those U-Haul vans that are going into Tennessee, I can guarantee you a lot of them are coming from California. In fact, I know 2 people in recent years that have moved from California to Tennessee because of that reason. So thank you for taking our excess housing supply shortage in Tennessee.
I hate to admit, I'm actually from California as well, Jim, from Tennessee, moved here about 3.5 years ago. But I do see how rough it is out there, with housing shortages. But I'm kind of moving on to Jason. Anything to add to the issue of housing shortages here in Tennessee?
Well, as Jim said, it's not like one single driver. We've seen one study suggest that government regulations account for 24% of the average home sale cost. John, I think it's actually higher than that, being in that world. But a lot of this does have to do with the types of homes that can or can't be built. So when we looked at the Middle Tennessee zoning restrictions in our Middle Tennessee zoning atlas that we published, nearly 60% of land in Middle Tennessee outright bans duplexes. When you look at more dense housing, triplexes and above, that's 94% of land. So it's almost like a government created problem that where developers say, hey, we can build more affordable housing for the average Tennessean, and the government basically outright bans that type of housing.
And John, moving on to you, what are the biggest challenges that you're seeing related to housing shortages?
Well, I think it's basically all of the areas in Middle Tennessee. If you go back maybe 20 years ago, we had one county that was pretty much, setting themselves apart, where they used to have median income housing being built, and they were the first to come up with these regulations. And lo and behold, by doing that, their school ratings all went up, their crime rate went down. They were basically homogenizing themselves to be, a wealthy, affluent county, kind of a gated community without the gates. Well, now it's everywhere in Middle Tennessee. I will say that if you go about 50 or 60 miles southeast, there's a community that one of our builders has just opened up that they are offering homes for like 280, single family homes for 280, but it's in Manchester, Tennessee, and they are all vinyl front entry. They're just what we described. But most of the areas around here copy each other's regulations or attitudes. The other thing I'll throw in, and I think Ben is sort of hitting on this. I know Jim is I talk about the homeowner class. Judges are members of the homeowner class, and I've had where they've asked questions where they were concerned about the open field behind their house. Someone coming in and putting in an affordable subdivision, but the other big challenge that's hitting us now, because we have restricted supply, and there's investors that have realized that that's not going to change legislatively. And so they're betting on there always being a shortage of housing. Real estate has become a store of value. I mean, it's almost like an even safer Bitcoin. So there's a lot of money flooding in to housing, driving up prices because investors are buying them. Like, what am I going to do with this money? I don't want to go to the stock market. I mean, I don't want to keep all my eggs in one basket. And that's one of the problems that we're facing as well.
And Ben, I know we've talked a lot, we've kind of mentioned every topic here. Did you want to touch on anything from the legal standpoint on the housing shortages?
I mean, I think we're going to talk as this goes forward about, we mentioned permitting and delays, which I think is a big issue that Beacon's working on. And then we also have the issues of impact fees, which are just also another addition to having a problem. So an impact fee is basically where the government says you got to pay a traffic road fee before you build your house. And a lot of the times there's really no proof that you making that home is even really going to increase traffic 5 miles rather than build a new road, that money. But those are happening as well. And Beacon's been tackling those types of cases as well. And so I'm sure you'll ask more about those, but those are other examples as well. As we have legal kind of beyond just saying what you can't build, they slap fees or delays on top, which also make, increased costs as well.
Yeah, and we are going to get into impact fees, but I do want to hone in on a big one here. One of the biggest is permitting. I know that you briefly mentioned that as well a little bit earlier, Jim. Permitting, to many people, maybe it sounds boring, but it's actually a really big thing. As we know, delays, costs, inconsistency, it all adds up. So Jim, what can you say about, permitting challenges, or even, what are the legal consequences when permitting does become a roadblock?
The consequences of excessive permitting requirements and permitting agencies not working well with homeowners is that there is going to be fewer and fewer buildings. I mentioned earlier about the fire in Santa Cruz in 2020 that destroyed 700 homes. There was a grand jury. And one of the findings was that people are not rebuilding because they were, quote, dispirited by lengthy and often bewildering permitting processes, that no amount of money could see them through to the completion. And one homeowner said to the grand jury, or former homeowner, they fight me all the way through. The idea is that you have a permitting agency. It's supposed to, in theory, help you get something built, something that is going to conform to health and safety requirements. And they're supposed to work with you on that. But more often than not, the stories I hear time and time again from anybody from big developers to somebody just trying to build an addition to their home is that they have to go through so many processes, so many studies. You have to get a survey of your neighbors to find out if they're going to be happy with what you're trying to build, essentially giving them a veto, which the Supreme Court said a number of years ago is unconstitutional, but that doesn't seem to bother a lot of permitting agencies. And the permitting agencies, of course, they work except for coffee breaks and donut breaks and lunch breaks from 9 to 5, except when they're on vacation, which seems to be all the time. I mean, I'm sure John has had this experience. He's going through the permitting process and you call up and say, well, this thing has been on my desk for a few weeks. Oh, well, that person left. Oh, that person's on vacation. The file's been transferred to somebody else and you have to start over again. And it's no skin off of the back of the people in the permitting agency because they get paid 9 to 5. They're going to come out after 20 years and have a nice government pension and everything is fine. But if you're trying to build something, it becomes extraordinarily difficult. And so it gets back to you have a right to use your property. It's called a property right. That is the idea that has come from Anglo-Saxon law from the time of the Magna Carta to the present. But if that is so hobbled with so many conflicting and difficult permitting requirements, I ask, what kind of right do you have left? And that is why Beacon and Pacific Legal Foundation and others are trying to litigate this issue to restore property rights. So the permitting process is a process, not a permitting, round hole where your project goes and forever dies. We have to restore the right to build property. Otherwise, we're going to get into this mess worse and worse and worse.
And it's interesting you mentioned the delays with the permitting agencies. I was a news reporter before Beacon, and I would see the emails with the permitting agencies and builders or developers, and it would be weeks or even months in some cases that they would even get a reply, and then you can't even go on to the next step. So I've seen that firsthand as well. But Jason, maybe you could kind of touch on this. Are there any policy proposals to streamline permitting or, research on current permitting delays across Tennessee?
Absolutely. Having kind of an expedited approval and review of permits, giving a set time frame for when a permit is applied for and when it will be approved or denied. If that time passes, it can be an automatic approval or have a third party that can actually go and approve the permit. And then if it is denied or opposed, that there is a set time frame that the city will provide a reasonable answer as to why it was denied or opposed. Another way we can kind of speed up some of this housing is housing by right. So if a proposed development, whether a large one or just an individual wanting to build their dream home, meets all the zoning and land requirements already set out, they have the right to build their home on there. So that kind of goes through the regulatory bodies that can have discretionary review and really clog up the whole system of wanting to build, your dream home on your property.
And John, I'm sure you could speak on this from, the Home Builders Association. You're obviously in this process probably daily. So how does permitting affect timelines and budgets for someone like you?
Well, let me add one of the things that Jason's talking about. So we just passed a law that allowed builders to opt to use third party, and where you'd have a licensed engineer or someone that's licensed with a code, the International Building Code, come in and do an inspection. But the caveat to that is we still have to pay the city the permit fee, and we have to pay the third party, which when you talk about time being money, builders gladly pay that because they would rather get their inspection done or their permit issued in a timely manner than wait 30 days, 90 days, what have you. And we also did that for septic systems, which everyone is paying third party to get their septic systems approved. So I think the point that I'd like to make is, yeah, obviously time is money, but it's not. When you start talking about what I originally talked about, getting a subdivision approved, that's a political process. Permitting is supposed to be about regulations that are already written down somewhere. And there really isn't interpretation for it. Like if I come in, this is an old book, but if a builder walks into the codes department, wants to pull a building permit, what they're going to do, I'll hold this up. This is the International Building Code. It's it's blurred, I guess. It's a voluminous book, but basically you're saying, I'm going to build a house. That's 2003. But if you're under the 2018, I'm going to build a house that complies with this code. And that should really be the end of it in the sense that the inspector goes out, makes sure it's built to code, and you keep moving forward. And that was the way things were 30 years ago. And now, everything's sits on a desk because there's interpretations, and they look for conflicts between their own regulations that they can use to hold up projects. So, most time developers are trying to factor in that cost of delay into their lot price. And keep in mind, we've thrown out a lot of formulas. Basically, lot price is going to convert to about, you multiply the lot price by 4, and that's usually your end product, at least in Tennessee. I think that ratio is a lot higher if you go to the coast. But all of that conspires to make housing less affordable. And just to go into the politics again, A lot of city councils are fine with that. A lot of mayors are fine with that. They're, they don't want to explain to their constituents, why that cow pasture that they've always been able to look at the back of their house is now an apartment complex. It's very unpopular. So it's kind of, the permitting process is problematic, particularly when you've got impact fees attached to them. I think I know the original study on from HUD on NIMBYism and the cost pegged it right around 25% is unnecessary regulations. It's got to be way higher, that percentage. So that's where we are.
And Ben, we have here at Beacon. Sorry, there's a train. I'm not sure if you guys could hear it. That's why I paused for a moment. But here at Beacon, where I am in the office, we have lots of legal efforts on permitting reform. So let's talk about Richmond Road case and what happened there.
Yeah. So kind of just to go off where everyone's talking about permitting, one of the major things is delays. So if you poll developers from the studies I've seen, which we cited in our Supreme Court brief, permitting is actually the #1 cause of delay. And I think there was a study from Seattle and LA that showed 1 month of delay can cause between $4,000 and $5,000 for an apartment unit. So if you would delay for 2 years, that could be $100,000 in costs you just put, on those developments. And so what happens is there's multiple ways governments can delay, and I'll kind of use how our case happens, right? And so governments put pauses on building, which is called moratoriums, where they say, hey, you can't build for 6 months, 2 years, and try to pause it. Governments can also kind of deny by delay, meaning they never fully deny your permit. They just keep asking you for more little things. I had a case in private practice before I came to Beacon where the government just sat on the permit for 9 months and just never made a decision. And you'd ask them, hey, I'll be next council meeting, we'll talk about it. Then it wouldn't be on the agenda. And at that point, they're stopping you from using your land even without even making a decision yet. And what can also happen is that they can deny your permit kind of erroneously, that maybe you are zoned to do that, and NIMBY's in your neighborhood, which for the attendees who don't, that word's been thrown around a lot. That means not in my backyard, which are basically in other areas of law, you generally have to have standing, but in land use, it's like a legal outcome in the case. But in land use, just people in the neighborhood can come by and oppose projects. And so a lot of delays also happen where NIMBYs come in and don't want a project, and the city council will deny the permit, even if the property owner actually has a legal right to use it. And that's in our case, Richmond Road, which is Beacon's first Supreme Court cert petition. And what happened in that case was our client wanted to lease to Step Forward, which is a nonprofit Head Start program that helps low-income families for pre-kindergarten educational purposes, which is obviously like super great thing to do. Families need it. It was in a great location, and they're going to build like a little park and classrooms. And a neighbor in that neighborhood did not want it. They were saying how it was very classy, and I think they meant that in a maybe derogative way. I'm not sure, but the bottom line was they didn't want it there. And the city council and city planning commission ended up denying the permit, even though the zoning in that where our client's property is was specifically zoned for nonprofits and educational uses. And so it was pretty clear it was in there. And so our client went to state court in Ohio and said, hey, I can actually do this, right? And so it took a year of litigating in state court for that. And the court eventually said you could, they should have given you a permit. You are zoned for that. It was, however, that whole year, just 1 year, not even that long, just 1 year, they lost the lease. So they lost millions of dollars in revenue. Step Forward had to find a new location, get those costs, which is convenient for them. And so, during that time, they're trying to get their permit reversed. They actually sued for just compensation under the takings clause, which people don't know that. It's the Fifth Amendment. If the government takes your property, you get just compensation. And that can include even sometimes regulations that go too far, really restrict your use. You can sometimes get just compensation for the government's use. And so the problem here is, though, is that many courts do this thing called extraordinary delay, which is even if you lost millions of dollars in a year or two from a delay that was wrongful from the government, it's not extraordinary. And by extraordinary, it's not just the length of time, because there's cases for 10 years considered not extraordinary. It also considers like the government's motive. So you have to prove animus on part of the government agents, which is really hard to do. And so This case went to the Sixth Circuit, and the Sixth Circuit said that it was extraordinary delay, and so there's no taking. And so Beacon's cert petition is trying to get the Supreme Court to take this case and make it easier for landowners to bring taking challenges to permitting delays, which would, it's not a guaranteed win every time, but it at least allows property owners to go to court, get just compensation from the time they weren't allowed to use their property, which can be massive damages. And it also allows them some recourse that if governments maybe knew they could be sued more for this, they also might behave differently as well. And so that case is currently being litigated for a cert petition, which doesn't mean we actually are in the Supreme Court. It's asking to take the case. And so, yeah, hopefully they take that case and we can make it easier for landowners. Supreme Court can finally make it easier for landowners who were delayed through the permitting process to at least get some compensation for the temporary delay of using their property.
And I do want to kind of go back. We only have a couple more topics, impact fees and property tax caps, and proposals there. I'm going to go a little out of order with our Q&A because we have a question on impact fees. So I'll kind of go through this sort of topic, and then at the end of this topic, I will bring in a couple of these. So I would like to add, or I'll save that question kind of after this, but Jim, did you want to even talk about what impact fees even are, just to kind of set the tone and how we can attack them?
Sure. Impact fees, I call them developers as ATM machines. You want to get a permit to use your property, and government will use the opportunity of you needing a permit to ask something in exchange. We are representing today a client named George Sheets, who we just got back from the Supreme Court about a year or so ago. And he was trying to put a manufactured 1,856 square foot home, smallish home, on 10 acres of property in rural El Dorado County, east of Sacramento. He was told to do that, he would have to pay a $24,000, $400 transportation impact fee, of which $2,400 was to improve an interchange at Highway 50 about 5 miles to his west. Now, he said, look, I'm just me, my wife, and our grandson that I'm raising in a small manufactured home. Well, how am I going to cost $24,000 in impact fees? And the county said, oh, we have a study to show there's a need for it. Well, in fact, they had studies that were basically make-believe, and most of the impact was caused by commercial development, but they didn't want to charge commercial development. They wanted to charge residential units. And then the county said, well, we can do this because we are a legislative body and we are really not constrained by some of the constitutional restraints. What were they talking about? They're talking about a case that we had in 1987 called Nolan versus California Coastal Commission, where Marilyn and Patrick Nolan wanted to replace a little one-story bungalow with a two-story home. And the Coastal Commission said they would have to give up 1/3 of their beachfront property to the public in exchange for a building permit from the Coastal Commission. And they objected, and it got all the way to the Supreme Court, where the Supreme Court said there is no relationship between any impact caused by the Nolan's development and this beachfront property they have to give up. The Coastal Commission said, well, people driving down the highway would look in the direction where there is now a two-story home, where there used to be a one-story home, and they would have a, quote, psychological barrier, end quote, to realizing the existence of the ocean. Now, psychology is really important in California, but the Supreme Court wasn't convinced, even in California, that was justified because, as Justice Scalia said, wait a minute, people driving down the highway looking in the direction of the home wouldn't see any of the beachfront that the Nolans had to give up to the public. And the Supreme Court called this an out-and-out plan of extortion and said there has to be a relationship between the impact caused by the development and the thing you are asking in exchange. In subsequent cases, the Supreme Court said that thing can be money as well as land. It also said that the relationship has to be roughly proportional. Now, in the Sheets case with George Sheets, the county said, well, all those other cases dealt with exactions in a permit process, but we passed legislation and had a legislatively adopted formula so the constitutional constraints don't apply to us. And the Supreme Court said, no, they do apply to you. Go back. And we are now litigating this case again. Court of Appeal just gave a mixed decision, and we're continuing to work on the case. But the bottom line is that the occasion for getting a permit is not the occasion for demanding whatever government wants at the moment, more money or whatever. Impact fees are hugely expensive. George Sheets is $23,000 for a mortgage for a manufactured home is nothing compared to some communities in California where the average fee is $156,000 per housing unit. That's a lot of money. And it's also largely unconstitutional. Most developers will say, I just want to write the check so I can get the permit. I don't want to go through litigation to have and force the government to prove the relationship and the proportionality. But the bottom line is the more developers that actually want to sue, or small individuals like George Sheets or the Nolans, the better off we're going to be to rein in some of these runaway impact fees.
Ben, anything you wanted to add on this?
Yeah, so that's actually a really good segue into one of Beacon's new cases is our stormwater case, because Jim just gave a really good overview of kind of the legal rules, but how a lot of landowners don't actually want to pursue litigating that. So just from history, for people that don't know, Beacon brought the famous sidewalk lawsuit in Nashville. They're making developers build sidewalks to nowhere or pay a fee. Beacon won that, the Sixth Circuit, and got a settlement. However, one of the biggest problems with that case was that once that case was over, property owners wanted to get refunds back from the money they paid into that, but the city was denying lots of those for statute of limitations, which basically saying is over a year ago, or that you didn't pay it under protest on your check, so you agreed to it, or other procedural hurdles. And so, we were trying to look for a new case where we can make an impact for not just our clients' lives, but maybe like more citywide or countywide as well. And so what Nashville ended up doing for an impact fee was a thing called a stormwater capacity fee. And it was meant to fund Nashville's capital improvements for their stormwater system. Yet rather than either increasing the user fees for every user or use their general budget to do that, because everyone benefits from the stormwater system, Nashville decided to target only individual developers. So it went all the way from building a porch on your property, a new deck, to building a whole development. So it applied to every range of things. And it was 71 cents of square feet of impervious surface area, which is basically area that water can't go through. So it's like your concrete roofs, those kind of things, aren't grass or gravel. And so they were charging 71 cents, and that might not sound like a lot. And so for our client, he had a house. He wanted to expand it because he was having more and more kids. And he got slapped with this fee for adding, I think, doubling the size of his house, or the exact numbers. But he not only was charged for the impervious area that he made, he also was charged for his existing impervious area. And so it ended up being $6,000, which might not sound like a lot in that fee, but he got charged for what already existed. And he also gets charged for, if you're a family trying to add on to your home to make, have more kids and send them to school and make college funds and have groceries, $6,000 is actually a lot. And if you add that up across even bigger developments, it'd be higher and higher. And so what we did in that case was we thought that case was kind of what Jim described, that it was a Nolan and Dolan issue, and that it was unfairly targeting developers and homeowners to pay for a general public good that really the whole public should pay for through general taxes or user fees. And so we brought a class action in that suit to avoid the problem in sidewalks, so that everyone who paid into it could actually get their money back. So we filed a complaint. The city of Nashville did not even fight us on it. They didn't respond. They didn't which is called answer our complaint. They actually came to us and opened up settlement negotiations. And a couple of weeks ago, we actually had the federal district court in Middle Tennessee approve our preliminary class action settlement. And so right now they should be mailing out all the forms to the property owners who paid that fee. And so I think total we have 361 people getting paid back. And so I think that's really good, because it's not just our client, which he deserves his money back, but it was everyone who paid. And I think it's over $1.4 million. And so hopefully, a class action can be a useful way to do this because, like Jim said, individuals don't want to fight over $8,000, but places like Beacon or PLF that don't charge their clients, and we do it pro bono for our work, a class action could now be a powerful tool if the facts are right to have a class action to fix those problems, because it'd be higher money for the city to pay out, and they'd be less likely to want to keep doing those kind of fees. And I did see someone in the chat mention fees
Yes.
about how how do you pay for expanding your cities and utilities and things. I mean, governments can pay. The problem is city governments have bloated budgets. They waste a lot of money on things, and rather than doing what they're supposed to do, like fix roads, make utilities, or basic government services, they expand a bunch of things, and rather than cutting their budgets and being responsible in how they manage, they want to use, like you said, developers as an ATM. And so a lot of impact fees are not that related to the development. Now, there are things you can do, like if Costco built off a highway and was going to increase traffic congestion, and the government say, hey, Costco, widen the road here off this exit because it's going to be coming out. The Supreme Court allows you to do those kind of things, but routinely what we see that's not what happens. They just kind of want money or land from developers that aren't tied to their impact. And so I think governments just need to be more responsible with their budgets, and actually have the whole public as a whole that benefits off things like roads and utilities actually pay for them.
And I'm not sure if Jim or John wanted to chime in on this one, because we did get that question on the topic of impact fees. What are alternatives to paying for the increased strain on utilities with increased zoning density? Did you guys want to touch on that one?
Well, I'll jump in real quick, and we've grown as a community for 100 years, and we've been able to pay for infrastructure because those houses are going to be paying property tax that help pay the bonds that help put in the infrastructure. And they're also paying sales tax, by the way. So the money's there. To go to Ben's point, they've just allocated it to different things. And I think what's really insidious about it is we have some laws that prevent like county impact fees here, but we do have city impact fees. Anytime you're going to approve an impact fee, you're basically saying, okay, everybody who owns a house, your infrastructure is paid for with your property tax and your sales tax. All of you new people, you have to pay the same property tax, the same sales tax, plus a fee. And the city has no intention of refunding that fee over the years through your property tax. You're just paying more for the same services. And people think, well, no, they're new services because we're putting in new roads. Well, there were no road, people act like there were no roads when they built their house, or there were no schools when they built their house 30, 40 years ago, when in fact there were. And so I don't like people say, well, how does growth pay for itself? It more than pays for itself. We've done studies in all of the counties in our area, and revenue outpaces population growth 3-to-1 everywhere, because there's so much money coming in from like I say, sales tax, property tax. So it's just a question of fairness in my mind that everybody should be getting the same deal. Frankly, that I got for the house that I'm in. My house that I'm in now did not pay any impact fee or any privilege tax or anything like that. And my children should be able to buy a house that didn't pay those fees as well.
And kind of last piece of the puzzle here, because we don't have much longer, probably about 10 minutes. So I don't want us to skip property tax cap proposals. Property taxes, they keep going up. Many want to see a cap of some sort to protect homeowners. Jim, what are your thoughts on that topic? I think you're muted.
As government policies cause an increase in housing prices well beyond the level of inflation, when you have property taxes that are based on the value of a home, and that value of the home goes up and up each year, property taxes go up with the value of the home, which often is far in excess of inflation. As a result, you have people that are having greater and greater difficulty affording the property taxes on their homes. And when that happens, some people, especially elderly people on a fixed income, lose their homes because they cannot afford their property taxes anymore. They lose them into foreclosure sometimes, and they get a fraction of what the cost is house is worth. We've had litigation trying to get people more money for when their houses are foreclosed. But the bottom line, property taxes are going up faster than costs. And because the local government gets more revenue from these increased property taxes faster than they're spending it, well, they find new ways of spending it, but they don't need to. And so there is a push in a lot of areas to have a limit on property taxes. California famously passed Proposition 13 in the 1970s, which limited your increase of 1 to 2% per year once you bought your home, so you know what your taxes are in the future. It is it's a rather blunt instrument to take care of a problem. It has had some effects that you have to think about when you adopt a property tax cap, is that because when homeowners own their homes long enough, they have a huge disincentive to move, say downsize to a smaller home unless the taxes are portable. We've done that to some extent. But also, as more people own homes for longer periods of time, the tax revenues become diminished and communities have less incentive to approve new housing because I figure they're going to get less taxes in the long term to support services. So a tax limitation has to be very carefully done, and look at the examples of California's Prop 13. Every time we have a tax limitation, governments try to find a way to evade it. So we've had to go back to the people time and time again to have new legislation, new initiatives to close the loopholes that government is able to find. But bottom line is that taxes should be commensurate with the cost of running government. And that is a slim dieting cost of government to finance itself, and not simply going up and up every year because the house prices are going up and up because of government policies creating a shortage, therefore a lack of supply, therefore higher prices.
And since we don't have much time left, I do want to get to a couple of the questions. We have about 8 minutes left. I'm not sure who would be best to answer this one. We did get a question from an anonymous attendee that says, what, if any, data sources have y'all looked at to measure the effect of permitting delays on housing prices? Potentially, Jason, you wanted to answer that one?
That would be quite difficult to quantify. A 1 month permit delay for an individual building a accessory dwelling unit on their property uh, may cost something different than full development that's something John would be building. So to get a exact dollar quantification for that would be very difficult. But we have heard so many stories from people in Tennessee and other states where time is money, as John said, and it is a cost that kind of gets baked into the pie where I'd rather pay more money for that third party to come out and approve my permit than wait for the government. So that's an additional cost on there. But as for a full kind of database that we have, I think it would be very hard to quantify.
Well, and I know, so in our CERT petition, which you can find on our legal case page at our website at beacontn.org, we actually have studies, though, some studies and some even polling from developers in our legal brief talking about the cost that delays due to housing. So I did mention, and usually these are from more cities, but I did mention like in LA, I believe there was a study where I think I mentioned where every month of delay to a housing unit roughly did around $4,000, I think a little more than that every month of delay. And so, well, I think it is hard to quantify. I think there are studies out there that show that delays keep increasing costs, which makes sense because you have loans going, you have capital equipment, you have other contractors, subcontractors. I mean, there's so many moving pieces. I'm sure John knows about that as well in construction and things like that. That when you keep having delays, you're just going to keep having costs that keep going up.
And if I may, in a shameless plug of self-promotion, in my book, Nowhere to Live, I cite to a lot of studies on the economic impacts of permitting and zoning and other issues that government makes it more difficult to zone. So the book is on Amazon and it's on sale for the Kindle price right now.
And another question we got from an anonymous attendee, how have Tennessee appeal processes for developers affected the permitting process or impact fees? Not sure if John would be the best for that one or.
I think you have to understand that we're talking about two separate processes. The basically the rezoning or the approval of a neighborhood, and then the permitting process. And the lawsuits that we see from developers are after it's been approved, it's got preliminary approval, and they have begun building, and something has changed as far as what's being enforced on them. Other than that, we join with Beacon Center and other groups as far as challenging impact fees and things like that. But like, Jim said, the developer wants to keep moving forward. I've seen developers at city council meetings where the city council just thought up a number, a per lot number, $4,000. And the developer looked at his assistant and said, pay it, and walked out because he needed the approval. They needed to get going. So, and they did not have time to go through a 3-year, 4-year process. I don't know when Sheets was originally filed, but I know it's been a long time, and we're still hoping for some better, a little more clarity on the second time around. So, and the other thing developers think about is there is a cycle, to building. I don't know if that's true in the last 10 years, but back in the 80s and 90s, if you got held up and you weren't selling while times were good, and all of a sudden now you're putting product out there, maybe interest rates have gone up, maybe jobs have gone down, those sort of things, that's a huge risk. So they are all go, all gas, no brake, trying to get these things out of the ground. And on the best project, the quickest project, it's 2 years. So that should give you a feel for what they're trying to at least get it ready to build in 2 years.
Yeah, and real quick on that, like you said, the two differences. There is also the internal appeal process with like the government entity itself, which you can go through rounds of appeal of their permitting decision. Then you go to courts, which is afterwards. And the problem is that each one can take years and years, and all these layers and layers and layers. And I think at Beacon, which our case Richmond Road's trying to do, is the faster property owners can get access to the court system to litigate these. It's not a panacea to all problems, but it will help because there's just so many layers and layers of internal appeals that by the time you get to court, it's too late. And it's been 5 years. In our case, it's a good example. It took 1 year to get their permit denial reversed, and they already lost their lease. And 1 year is actually pretty fast to go to a state court system. So, that's a problem. And I think the overly appeals and doesn't really help developers. And the faster they get to court would be better for them, I think.
Well, I think that we should probably start wrapping up so we don't take too much of people's times. But a very big thanks to Ben, Jason, Jim, and John, and obviously to all those who have joined us here, because we know this issue affects everyone from builders, buyers, renters, families. So if you do believe in affordable housing and you care about protecting property rights, we urge you to stay involved, stay connected with Beacon. You can visit our website, share our research, and join us in advocating for this. So again, thank you to everyone.
Thank you.